Good evening. This is Harold Watson, Zoning Chair of the Stratford Zoning Commission, that now sits for its regular public hearing and administrative meeting for 2024 on Wednesday, January 24th, 2024 at 6 p.m. Quorum for this meeting is 4. I will now call the following elected commissioners. Zone 1 Commissioner Linda Manos. Zone 2 Commissioner J.F. Ewald Joseph. Zone 3 Commissioner myself, Harold Watson. Zone 4 Commissioner Len Petricelli.
Here. I'm
And
5,
zone-
actually.
Oh, sorry, I have these backwards. And Zone 4 Commissioner Deborah Lamberti. We also welcome our alternative in attendance, Dave Fuller. We also welcome Jay Habansky, our Planning and Zoning Administrator. Gail, oh, sorry. You're Liz Cameron. Our Recording Secretary, Patricia Sullivan, our Zoning Legal Counsel, and the public may speak only at the invitation of the chair during both administrative and public hearings. With that said, I call to order this monthly session of the Stratford Zoning Commission at 6 p.m. All in favor?
Aye.
Aye. Anybody opposed? So it's 5-0. We will now move to our public hearing portion.
Mr. Chairman,
Yes, sir.
make a motion that we move items 2 and 3 to number 1.
Second, anybody? Second. May I also add something to that we have 2 petitioners that are not going to, we have 2 projects that are not going to be here tonight. Let me find it.
7365 Main Street and 500 Sniffens Lane.
Yes, those are being held up until February. So may we add that into your,
Yeah, I'll make that as amendment to my motion if the second would accept it.
second, anybody? Okay, all in favor?
Aye.
Okay. So our first presenter tonight will be the, or no. I'm sorry, the text amendment 225. Excuse me, I'm sorry.
Chairman, Commissioners, thank you for taking me out of order. My wife thanks you so I can get home and help put kids to bed. But yes, we are here for the application for 225 Lordship Boulevard LLC, Chris Russo with Russo and Rizzio offices at 10 Sasko Hill Road in Fairfield. We are opening a public hearing but asking for a continuance. There were some comments that came in from engineering, also comments from the zoning administrator, and suggestions that we are looking to look into over the next few weeks and come back to you for the February meeting. But because of the statutory timeframes, we want to open it and then preserve our extension time. So if there's questions that come up at the February meeting, we have that extension time that we could use to extend it if need be. So with that, we respectfully request a continuance. And I have our signed photos. We've submitted our mailings to make sure notice is all proper.
I want to say we're appreciative of what you're doing, so good luck.
Thank you.
Move that we continue item 2 and 3, 225 Lordship Boulevard, their text amendment, and 225 Lordship Boulevard, their petition. Leave it open for public forum next month.
Second? Debbie? All in favor? Aye. 5-0. Okay, we are now going to go to back to our original schedule, I believe. Deborah, can you read that for me, please?
Thank you, Mr. Chairman. Modify Bluebird Prestige versus the Town of Stratford Zoning Commission, FBT CV 1960666724, SAC 45300 170 Orinoco Lane, Attorney Bellis. that you're not Attorney Bell.
I'm not Attorney Velis. I'm Nicholas Owen, and I'm
For the
not an
record, can
attorney.
we get both of your names, though, and your town for our recording secretary?
Sure. Good evening, Madam Secretary, Mr. Chairman, ladies and gentlemen of the Commission. My name is Nicholas Owen. I have business offices located at 972 East Broadway here in Stratford. I'm here this evening in part along with a gentleman from the law firm of Pellegrino in New Haven, Mr. Bellis. Could not be here, however, this learned attorney is his compatriot, and he will be doing a major part of the presentation. I'll be here for questions and some clarification on the project if necessary. Before I start, what I would like to do, based on recent conversations with the engineering department, based on comments that they had, is pass out the most recent set of plans along with the erosion and control report that is required. The stormwater management plan is required by the engineering department, and I'd like to pass those out at this point. I also have, for the record, the receipts of mailing, which I might as well put in immediately. I missed you? I don't want to miss you, Linda. And Jay, I want to give you, give that to David, I'll give you a full set. Along with the storm management report, and I'd like to enter those in to the record as exhibits, and they will be discussed in part this evening. And at this point, I will turn this presentation over to the attorney from Pellegrino. Thank you.
Good evening. I actually also have some documents to pass out to you. It is the first modification of the settlement agreement that I would like to talk about, so I will distribute that now.
It's a test. Yes.
Mr. Chairman,
Yes.
through you, are you going to share that with the council for the town as well?
Thank you.
Okay. As I said, my name is Kenneth Chardello. I am an attorney representing Bluebird Prestige. I'm filling in for Attorney Bellis, who could not be here tonight. We are here because of a settlement agreement that approved an 11-unit development on 170 Orinoco Lane in Stratford. And pursuant to that settlement agreement, which in part I passed out to you, if you could turn to page 3, paragraph 6. Paragraph 6 provides that Stratford Land Use Boards retain the authority to make, evaluate, and approve development applications. Now, why am I saying that? We are here to request a modification to a site plan for 11 units and 0 affordable housing units. In that settlement agreement that granted that plan to my client, the site plan approved a mixture of 2 and 3 bedroom units, no affordable housing. We are here simply to request a modification of that site plan, not the settlement, but the site plan that granted the 2 and 3 mixture. We would like the new agreement to be all 3 bedrooms. Now, the authority to grant that modification of the site plan has been bestowed on this commission because of that clause that I just presented to you in the modification. This board has absolute authority to modify a site plan that was subject to the grand settlement that gave rise to this approval. Now, this settlement that we're speaking of condensed a number of lawsuits, and 170 Orinoco was one of the properties that was subject to that grand settlement that basically nullified all those lawsuits. So because there was an agreement that was granted by the court, a stipulated judgment that was entered and has become final, we believe that this commission has the authority to, in this instance, grant the request for modification that we are seeking. There would be no reason to go to the court to request any sort of modification of the settlement agreement. Importantly, because the settlement agreement never said anything about number of bedrooms in any of the units. It just said that there would be 11 units, or in this case, houses, that would be no affordable, and because we are not modifying a material term to that settlement, it is our position that this council has authority to modify that approval of the site plan because of that, and also, most importantly, I can't underscore this enough, that the settlement that was agreed on by the court provided the provision that I sent to you that says that this commission has jurisdiction and authority to modify, evaluate, and approve the development application that is before you. Happy to take any questions that you may have. Mr. Chairman.
Were we to say yes to this, when it comes back before us, the occupancy of your site has gone up at least 11 people more. Will we still have the ability to essentially rule on those kind of matters if we were to say yes now?
I don't see why not. And to point out, it wouldn't be 11 more occupants. The original approval was for 4 3-bedroom and 7 2-bedroom. So in theory, there would be only 7 more bedrooms. And you know, I wanted to point out that in this post-COVID world, a lot of these 3rd bedrooms are being used not as people's rooms, but as home offices, home gyms, anything like that. So there's probably not even going to be 7 more occupants in this development, in my estimation. And in terms of the neighbors, you know, this is only going to increase their property value. You know, I would want to live near a 3-bedroom colonial rather than a 2-bedroom colonial. So, you know, I don't believe that they would be negatively impacted either.
Going to turn to the committee members. Len?
So you had a signed agreement, but it was not specified. The units were specified, their dimensions and all that, but the number of bedroom units were not specified.
Exactly.
Okay. So whatever we decide here wouldn't affect the signed agreement one way or the other?
No, we are simply seeking a modification of the pre-approved plan.
Thanks.
Deborah?
So, did you go through all the steps to modify the agreement? Like speaking to the mayor and to all the steps that you needed to go to modify the agreement? Because the original agreement was, you know, the 4 and the 7.
Absolutely. And again, we apologize for even taking the council's time here. It was an oversight. It always was meant to be 3 bedrooms. It was an oversight on the original application that had a mixture of 2 and 3 bedrooms. And we want to just clear up that mistake. That's what this purpose of this application is for. And might I add, you know, because we believe that this commission has the jurisdiction and authority to modify this previously approved plan that was part of this settlement agreement, you know, we don't believe that there's any benefit in going to the court first to request that they modify it. These are closed, final judgments. And again, that judgment gave this committee the authority to make those modifications down the road if it were to see fit. Yes?
But going to the court is not, why didn't you go to the mayor? Because didn't she, like, agree to this, the original?
We have absolutely gone to the mayor about this. I don't want to speak for the mayor in this instance, but this is the forum that has the authority to grant and deny this application. That's why we came here.
You do understand, though, a zoning board would look differently on a 3-unit building, housing than a 2-unit. That changes the sewage, the water, the utilities, the parking. That does have impact on the overall property. So we might not have done as much diligence as we would have in a normal situation because of the judge ruling.
Understood.
So I don't know. It makes me nervous saying we're going to suddenly do a vote here that's going to be carried back to the judge saying it's okay with them. Keep talking.
It's our position that this doesn't even have to go to the court. The court has no interest in 2 bedrooms, 3 bedrooms, 5 bedrooms, so because that wasn't what was in front of them when they made their decision.
So is our option of going back to you and saying you need to alter your parking spaces in order for these 3-bedroom condos to have 3 parking spaces?
Well, they all have garages.
That's not 3 parking spaces.
Sure. Well, we do not have any response to that, but I could definitely.
Will you be coming back before us to iron out these specific things?
No.
Yep.
No.
No, the applicant is intending to get the approval today. So if you were to add additional parking, it would be done in this forum right now, not at some later date.
Correct. Our goal here is efficiency, not to bog down this commission with multiple hearings.
Thank you.
You are welcome. Hopefully this is the last time you ever see me here, for this matter at least. We just are simply adding 3 bedrooms to these houses, or 1 bedroom to 7 units. And the way they are laid out now is, at least the original 2-bedroom houses, they were 2 bedrooms and a den. Now that den could be used as a bedroom anyways. So the real impact here I don't think is that great, which is why we want to make this as efficient of a proceeding as possible. But I could turn it over to my colleague to discuss your parking question.
Yes.
Mr. Chairman, I would just like to, I'm looking at paragraph 6.
Yep.
I'm not seeing any modification language. And I believe that paragraph 6 was related to allowing the commission to retain the jurisdiction to make a determination on the text amendment that was for 600 Silver Lane, and then also to approve the development application. So in my opinion, what was before the court was what the commission approved. So if you change the approval, I think you would have to open the judgment. And then separate and apart from that, you would also have to amend the agreement, because it was, you know, called a global settlement, and it deals with a number of properties. So that's, I don't see the modification language in 6. I know you said that, but I don't see it.
I said modification, I might have misspoke. It was simply just evaluate and propose general development applications. But and to that effect, if you would, I would like to pass out a couple more documents for your review.
I would also just say that this First Amendment had to do just with 600 with Silver Lane, and it does include affordable units. So I'm not sure, you know, I just want to make sure we're talking about the same project and that we know the approval that we're looking for. And I think I would see this as looking for a plan moving forward as to what steps need to be taken by this commission, by the town. The neighbors are also involved in these, in that settlement agreement. And then also, you know, getting back to the court. And so I think there's a lot of steps here, in my opinion.
Yeah, I mean, and thank you for that, counsel. And in our estimation, that settlement or the modification that I passed out to you, it does list 170 Oronoque right on the first page as granting 11 units, no affordable housing, right in the middle of the first page. So it's our position that this document would impact the instant application. So if I could, to the point of why would we need to go back to the court to modify, I would like to pass out 2 more documents if that's okay.
Is it? It's because my phone is dying. Okay, what I have passed out was the motion and the judgment that granted the stipulated judgment that was dated June 21st, 2023. I've also passed out to you a second modification of the agreement that has been dated subsequent to June 21st, 2023. That second modification was never subject to any sort of court approval. So the proof is in the pudding here that this commission has the authority to grant modifications because there has been a previous modification of the settlement agreement that has never gone before the court. So to say that now, since we want to change the number of bedrooms, that doesn't seem consistent with how the rest of this case has been handled. You know,
especially given the fact that that court gave this commission the jurisdiction to modify the agreement.
I don't see that modification language. The one that you're talking about in the first amendment dealt
Right.
with the approvals that were going to be necessary for 600 Silver Lane. I understand that you've got this whereas clause in the first page, but the idea of the Silver Lane property development was because of the purported loss of units at 170. So
Right.
the agreement, the global agreement included permission to do additional units at Silver Lane in substitution for the units that were lost at 170. And not, so that language doesn't talk about modification to begin with. And secondly, addresses the text amendment that allowed the development at Silver Lane and also the development application for that property.
Right. I mean, modification is a term of art, and while I might have said modification, that language clearly grants this commission authority to make changes to this agreement. Number of bedrooms was never contemplated by the court. That was never in front of them. That was never part of the agreement. And to say that we would have to go to the court now to reopen a final judgment for something that the court never contemplated in the first place just seems silly and a waste of time.
There is give me one moment to look through this, because there is in this settlement agreement general release, August 21st, on the second page, item number 2, the Town of Stratford Land Use Board shall retain their jurisdiction and authority to evaluate and approve said text amendment and development application. So you're saying currently we have an approved development application?
Yes.
So you're here asking for a revision of that development application?
Correct.
Okay. Everybody understand that?
You know, I'm a little confused here. It's almost like we're in court. We're really not lawyers. We're not legal experts. What the hell are we doing here? Seriously, I'm starting to get a little annoyed that we're a zoning commission, and I feel like I'm sitting here as a judge. So what are we supposed to do here?
I agree.
You know, I mean, this is ridiculous.
Because of the fact that this was a court settlement, zoning took as much of a hands-off as we could do.
Right.
The only thing that we relied upon is that if there were things that were definitely against zoning in Stratford that had safety issues or application of size and square footage and all of those issues, that we still had the right to bring those up. What you're asking is something that would fundamentally change the way we reviewed a site plan.
I understand the commission's frustration with the nuances of what we're asking the commission to do. We know this isn't a court of law. We're not asking you to make any sort of judgment. We are simply asking for a modification of this plan, which is the ballpark of what this committee does. We are asking the committee to modify this previously approved plan, a small change from 2 bedrooms to 3 bedrooms, and I have outlined why this committee has the authority to do that. That authority was granted to this commission by the court that said you have the authority and the jurisdiction to make not modifications per se, but to reevaluate, to evaluate, and approve the development application. This modification is simply a new development application. It's a application to modify what has been already existing. Even though that sentence did not say modify. You have the authority to evaluate and to grant zoning issues.
What you're basically asking us to do is to rename a room. The room is already there. Right now, it's called a den. The house is the same size.
Exactly.
Right.
Exactly.
So if I had that house and you wouldn't let me have 3 bedrooms, I could still move my son or somebody in, and the town wouldn't get the tax dollars off of that because it's not being sold and listed as a 3-bedroom home.
Precisely.
Okay.
Jay, could you comment on, today we got engineering reports on part of this, in terms of water usage and sewer, and also MS4.
So, and we do have Commissioner Full over here who did have a question. I just wanted to make sure you're aware. But, so I know the applicant has been working with the engineering department to determine whether or not the town engineer is satisfied with the modified stormwater management plan dated January 1st, 2024. In the staff comments that had come after your packets have already been put together, I received an email from John Casey, the town engineer, stating that he believes that the project, that he is satisfied with the modifications that have been made from an engineering standpoint. However, there are still additional approvals that need to be sought from other agencies, WPCA, after the fact. So, and I know that there's some frustration about what you all are supposed to be doing here. My recommendation is to allow the applicant to make their presentation, ask any questions that you have, and I think that advice is going to be given to you on what the town council believes that you should be doing. So that's my advice.
I want to raise another point, though,
Of course.
because in our town engineer's report today, there's currently no sanitary sewer serving this property. So if you're now increasing it by 11 additional bedrooms, you're actually increasing service that we haven't established how to make happen yet.
Mr. Chairman, Nicholas Owen again. I have worked closely with Mr. Casey, town engineer, and quite honestly, I know exactly what you're reading. He pretty much says, briefly in lay language, that the sewer extension on Orinoco Lane that was granted a couple of years ago, and I was instrumental in presenting that petition, and the WPCA approved the extension. So there's been an extension approved to service this property. We also know that we have to go to WPCA to turn around and connect to the sanitary sewers once they are installed by us and paid for by us. This is at no town expense. And I think if you read his comments carefully, he says in there, and again I'll paraphrase, that it has been approved but not yet constructed. And it's, I'm sorry.
And what does he say about the MS4 permits? And
What had
the new-
happened-
The new standards that we have to live by, which is 1.3.
This particular development has a long history from 2008. And from 2008 until date, some of the standards for water clearing and water pollution, all of that, have been increased and substantially upgraded. And in this instance, we went from a 25-year storm to a 100-year storm as recommended under that MS4 regulation. And you should see in his comments that we do, in fact, comply with that. I worked very closely with Mr. Casey over the past couple of days to make sure that we had all of our I's dotted and our T's crossed, because I knew some of these questions would come up.
Okay, my third question that's related to that is, if you're increasing 11 additional parking spots, you're increasing that amount of impervious pavement. Does that affect how much runoff there will be off the property?
All right, that's a two-part question. First of all, we are not increasing whatever parking is there. There's more than ample enough parking, whether it's a den, a two-bedroom, or a three-bedroom. There are two-car garages associated with each one of these units, and behind those two-car garages
I'm
are
going to
two...
stop you there for a sec. Does that match up our current zoning?
Are you asking me, does the parking comply with the zoning regulations? It does.
If there were 3 units, 3 bedrooms instead of 2 bedrooms,
Yeah, correct.
they would be okay. All right, thank you.
That's what I was getting to.
Good.
Now,
Listen, I'm asking the questions. that I-
gotcha, and
that
I'm
I
happy to
see.
answer them. You will see that I've done my homework a little bit on this one. There are also some additional parking spaces.
Why did you do your homework?
Why did I do my homework? It's important.
I'm kidding.
Because I knew you would ask these questions. There were a couple of other comments that I will address briefly, and then I'll turn it back over to the learned attorney and you guys if you have further questions. There are also a couple of comments from the health department. They will be complied with, and they have to do with rubbish removal, fencing off the garbage containers, et cetera, et cetera. Other than that, I think that we have covered all aspects of it. My take simply from a development standpoint is that based on my reading, and this is NIC law, not real law, that the first stab at this is between you guys. If you guys say yes, and then if we have to go back to the court can turn around and say they are not going to stand in the way of a commission change in the plans. It's a moderate change. It's not a major change, and it's something that is in your legal purview to do. And that's why we're here first, asking for your approval and not going to court first.
I think most of the committee would agree with me then. Why did you bring this back to us? Why didn't you just go build the place and...
Well, Mr.
Yeah.
Chair, I'll tell you why, to diverge a little bit. That is the north end of town is a special area. Most areas in this town are special areas, and I probably built maybe 50 or 100 houses up in that area. We did a number of houses on James Farm Road. We built Alexander Drive, Coach House Road a number of years back, my brothers and I. Most of those homes are 3 and 4 bedroom. This, I think, this is a nice, neat, compact community, and the values up there are going to range from $550,000 to $650,000. Now, anybody with any sense is going to know that a 3-bedroom unit is worth more than a 2-bedroom unit. Not only is it worth more for us sales price-wise, it's worth more to the town for tax-wise, with no real serious impact to anyone.
Okay, I'm going to stop you there. Linda, do you have any comments? No, I agree with what he's saying. Okay. Ewald, do you have any comments? And
What's the difference between the bedroom and the den? It's still the same. I think they're being very honest about putting another bedroom there and not just doing it.
Look, to reiterate what I think it was Mr. Petroselli said, the difference in a bedroom and a den is a door, a closet, or an armoire. Who is to say that you, Mr. Chairman, went up there, bought a 2-bedroom unit, and decided to use your den as a 3-bedroom unit? No one is going to go up there and look to see if you're not going to get arrested for having a 3-bedroom unit. The only time that it's going to affect you is when they come up for reassessment every so often. The town is going to come in and take a look and say, aha, we have a 3-bedroom unit. It's going to cost you more money in taxes. Are they going to throw you out? Are they going to fine you? Are they going to bring you to court, throw you in jail? The answer is no. It's not going to
Okay.
happen.
Dave, you wanted to make a statement?
Thank you, Mr. Chairman. A couple questions, if I may. I've been on zoning before. We've had 170 before us before in previous commissions. First question, with the previous approval to the WPCA, that the approval to construct has been done, does this shift from the 2 bedrooms to the 3 bedrooms have any material change to that construction? Would there be, I know ultimately WPCA has to give a final approval on that, but does that change what was already approved for from a WPCA standpoint?
Absolutely not. The buildings are going to look exactly the same as they did before. As we established earlier, this is basically renaming a den to a bedroom. The houses are going to look exactly the same. There's going to be the same number of houses. There's going to be no impact from an aesthetic point of view, from a construction point of view.
No additional bathrooms?
No additional bathrooms, no.
Okay, so there's no additional showers, toilets, sinks that are going in?
No, absolutely not. And to clarify from a couple minutes ago, it won't be it won't be 11 additional bedrooms. It will be 7 additional bedrooms.
Yeah, and then why asking for this now instead of when it was initially proposed? Was that a clerical error? Was that an
Of
old
course.
business model?
Yep,
Okay.
of course. I appreciate that question. That is why we are here. It was a clerical error. It was an oversight with the application. It was always meant to be a 3-bedroom, and just in the preparation of the application, it went into 2 bedrooms and 3 bedrooms instead of 3 bedrooms.
You let the cat out of the bag. Tell me now, what are we talking about for the 11 units? How are they divided?
They are all 3-bedroom.
They're all 3-bedroom?
Yes.
Okay. So we have 11 3-bedroom units.
That's what we are applying for.
Okay.
And my final question is, say, for example, the commission hypothetically approves this
Yes.
to what you need. Everything's 3 bedrooms, all 11 units are 3 bedrooms. Say somebody moves in, and they originally intended for 3 bedrooms. And they say, you know what, I don't need that 3rd bedroom. I work from home, I have my side business, I have my own business. I'm gonna turn it into a man cave, a den, or a she shed, to be gender
Of course.
equal, of course.
Of course.
Would they hypothetically have to come back to zoning to say, you know what, I don't have a 3rd bedroom, instead I have a home office or a library? Say, let's just say the role was reversed, instead of going from 3, we're now going to a non-bedroom use.
I understand. I think it would always remain a 3-bedroom. I mean, I don't see a situation, even if you wanted to make it the 3rd bedroom into a man cave or she shed or gym or home office, why anyone would want to take that classification down to a 2-bedroom and decrease their property value. I would think that anyone who wanted to do that would just keep it a 3-bedroom and just functionally use it as a different space. If that answers your question.
Are there any,
I have a statement.
commissioners, go ahead, Len.
They could take that den, if we didn't make it a 3-bedroom, and turn that into an office. So whether or not we call it a 3-bedroom or not, they still have a room they could turn into an office.
Of course.
Okay, thank you.
Any other final comments? Patricia, would you like to make any comment? Who? Deborah?
However, have you considered the impact on, there's no age limitations on this, so it can impact the schools, it can, and I live in Orinoco Village, and, it's like, there's been a few accidents on Orinoco Lane because, and actually, my residents have complained about the flashing stop sign, but I'm happy because people blast through that street, like, especially, at the close of Sikorsky's Day, and it's really kind of treacherous sometimes. So, more vehicles or, school buses, more stops, it has more than just a simple impact.
Absolutely, we completely appreciate that. It's our understanding that the school system is not at its capacity, so adding 7 more bedrooms here, and if at max you want to say 7 more little kids, we don't believe that would tax the school system in a way that would necessitate increasing resources.
Jay, do you want to?
Mr. Chairman,
Okay, yes.
I think I'm getting really tired when I hear that, well, you know what, we're going to attract people with children to schools. We need to attract younger families to Stratford.
Absolutely.
We're a town for all seasons. We should be a town for all families also.
Absolutely.
I'm beginning to hear from a lot of people, that's not how they feel. But we do need to have younger families moving in with younger children. It's a plus for the town.
Absolutely.
All around.
And families likely aren't going to move into a 2-bedroom. They're going to move into a 3-bedroom.
Okay, I'm going to, unless someone else has a question, I'm going to end this, give you a little piece.
What, you taking control?
Well, do you want to keep, an hour from now, you're going to say, it's time for me to go to bed. Thank you very much. I appreciate it. Thank you very much. I appreciate it.
Thank you very much. I appreciate the opportunity to be heard. Thank you.
Is there anyone who wishes to speak in favor of the petition? Please come to the microphone, give your name and your town. There's no one speaking in favor here? I will ask again, anyone who wants to speak in favor of this petition? Hearing none, is there anyone who would like to speak in opposition to this petition?
Good evening.
Good evening.
Kevin Kelly of Kevin Kelly and Associates, 2505 Main Street, Assistant Town Attorney. What you have before you is a plan that dealt with property that was part of a court-ordered settlement. You have a court judgment that was entered, as you have the document that was submitted this evening, on June 21st of 2023. Now, that included, I believe, an 18-page or thereabouts settlement agreement, and then the first modification thereto that you heard, actually it was a 13-page settlement agreement, and then the first modification thereto. And you heard that the applicant drew your attention to number 6. I'd just like to read that into the record. It says that the Town of Stratford Land Use Boards shall retain their jurisdiction and authority to evaluate and approve said text amendment and development application. That refers back to item number 1. Item number 1 dealt with 600 Silver will file a text amendment to the Stratford zoning regulations together with an application to the Zoning Commission. It is not referencing 170 Orinoco Lane. It's referencing 600 Silver Lane. Now, as a point of reference and to bring everybody's recollection back, the global settlement resolved a number of issues by a number of parties. Among them was this zoning commission, the town of Stratford. There were other land use boards. There were also neighborhood groups and private citizens that all came together and agreed to the settlement. What happened was the boards and commissions, planning, zoning, inland wetlands, BZA, retained their authority. And in this instance, you had approved a plan that included both 2 and 3 bedroom units. That approval became part of the settlement that was then, subsequent to those approvals, was presented to the court that became part of that judgment. So when the applicant says that we were silent on units, it's really not accurate. The judgment included what not only the developer had come to this board requesting, but what was approved by this board. That then was incorporated into the settlement agreement, the court-ordered judgment, and now, if we want to go forward, we need to open that judgment. It's the only fair thing to do to make sure that everybody that was a party to that agreement is heard. So we believe that this application before zoning is really premature until a conversation and communication with the other parties occurs first, and then if there is such agreement, we would go before the court to seek an amendment to that judgment. And yes, if that would warrant, come back to the commission. But at this point, it's the town's position that it's premature to go forward. Any questions, Mr. Chairman?
Anybody?
Thank you, Mr. Chairman. The question is both for Attorney Kelly and for our staff here on zoning, Attorney Sullivan or Administrator Hibansky. So I guess a question would be a procedural matter. Could the commission then say, defer to this 3-bedroom request, be brought to the mayor's office, brought to other appropriate municipal boards, and then get their feedback before the commission renders any sort of approval from a procedural standpoint?
I can just answer on the town staff's behalf. And that was the suggestion from the very beginning when this application was submitted. We felt that some steps may have been, and I'm not an attorney, and my staff are not attorneys either, but it appeared that the people who originally made the agreement, the multiple parties, were not consulted as to this modification. And so I think that's the fairness component that Attorney Kelly mentioned here. And so I think that those items need to be taken, sounds like the advice from the town attorney is those items need to be taken care of first, and then once the town agrees to this modification, and the town may say this is a great idea, we should do this, but we all need to say yes. That needs to happen first. And I'm not sure if I answered, I finished that answer, which was, yes, I think that the appropriate action is to have those parties agree first, maybe the applicant withdraw their application, or deny it without prejudice. I'm not sure what the proper procedure would be, but those are some suggestions. And then once those agreements have been made between all the involved parties, then come back. And I believe that's what I heard you were suggesting might be an option. I believe that's the correct course, which was the applicant has been advised of since the application was submitted.
I will add, it essentially allows you to move forward, because essentially it's going to have a plan that's going to have bedroom or den written on it. That's not going to happen. We're not going to, town's not going to move it any further until a CFO needs to be issued. So I think that would allow us to do exactly what a mini process of you guys going back and talking to the parties involved, saying, are you okay with this change? Does that make sense?
Where we get to our administrative session, I'll have some of that.
Okay. Is there anybody else who would like to speak?
Mr. Chairman, before just for the record, I want to make it clear that in this instance, I'm representing the town of Stratford. But I do want to thank you and the other commissioners for their service, and thank you for the opportunity to speak with you. Thanks.
Mr. Chair, members of the commission, my name is Joe Kubik, and I'm an attorney with Harlow, Adams & Friedman in Milford, Connecticut, and I reside at 1350 James Farm Road. We're neighbors. I represented through over 5 years of torturous zoning hearings, litigation, the concerned citizens group of Stratford were the neighbors that opposed the multiple projects that were being presented. James Farm Road, a couple on James Farm Road, Orinoak Lane, and Peters Lane. We fought the good fight. We were there at every meeting, and we presented our evidence to try to control what were obscene plans at the time, 130 units on like 3.5 acres. It was quite intense. So over 5 years of this, we finally got to a point where we actually had settlement discussions. We had to bring in a retired justice of the Supreme Court to essentially mediate this. It took many sessions of mediations to come up with an agreement. The attorney for the applicant that is here tonight actually drafted the settlement agreement. There was tweaks to that, but in reading the settlement agreements and looking at plans and understanding what was being presented, my clients were certain that what was being presented were 2-bedroom units in part for 170 Orinoak Lane. Now we have a situation where there's a court judgment. There's a final judgment, hasn't been appealed. 4 months have passed, so you can't just automatically try to reopen the judgment. It is a court order, it is a judgment, and the only change to this modification, to this agreement, has to stem from the courts issuing a modification of the judgment. I don't believe that this commission has the authority to change this application today, unless the court orders it. That said, you've heard something about this modification, the right to modify, but that's really not the language. But this paragraph 6 in this modified agreement that you've seen, it talks about, that's all about 600 Silver Lane. That has nothing to do with 170 Orinoak Lane. Really, the essential part of this that I'm seeing is that the applicants have decided, if we have 3-bedroom units, even though we presented 2-bedroom units, we're going to make more money. That's what it's about. It's about making more money and trying to usurp the power of our court system by coming to you and having you asking you to issue an order that I don't think you have the authority to do. That said, obviously my clients are opposed to the granting of this petition that's before you today. Thank you.
Is there anybody else who would like to speak for or against? Hearing nothing, I'll entertain a motion.
Motion to close. Does the applicant want to respond?
I would love to, thank you. I would first ask, who else could grant a modification other than this committee? The court isn't going to grant a modification. They don't have that expertise. They defer to these boards for that. As far as giving the opportunity for parties to be heard, they could have been here. They could be here at this proceeding. There was public notice of this hearing. They could have been right here. And as far as this being about money, this is a good thing for the town. We have established that the more young families that can enter this town, the better. And this plan would give this town the opportunity to welcome more young families in, and we believe that this commission has the authority to grant this modification. Who else would do it but this committee? Thank you.
I'd just like to make a suggestion before any of this gets closed. You may want to carry it over and see whether the applicant and will approach the town. And I mean, it is my opinion that you need both. You need both the commission to agree and you need the court to agree. And having one or the other is not help. It doesn't solve the problem. I do think you have to open the judgment. This was the settlement of pending litigation. And it was settled on particular terms that the commission agreed to. So that's just a suggestion. Rather than perhaps closing the hearing, you continue it where we can, have more conversations.
If I may, we would also be amenable to a situation where this committee votes on this modification with an understanding that the town council and my counterpart, Attorney Bellis, could discuss how they want to present this to the court. But I just don't see how there's any reason why there couldn't be an approval by this commission on this issue tonight, that maybe the town attorneys and Attorney Bellis could work out a way after this meeting to present this to the court. If that would make this commission more comfortable, that everyone would have a right to hear, that would simply eliminate the need to be here tonight, go to the court, come back here for another presentation. We could simply at least mark off one step tonight.
But if you were to come back to this committee saying the judge says we're okay,
Mhm.
it's an easy thing to do.
Of course.
I move that we close the public portion so we could discuss this in our administrative session.
Okay, we're now going on to the second.
Second.
All in favor?
Aye.
5-0. Next one we have on our list tonight is
Where is it?
research drive. Linda, can you read that?
Sure. Number 4, 10 Research Drive. Petition at 10 Research LLC seeking a special case to construct a 30,000-foot manufacturing facility and incidental site work in an MA zone.
So, those applications requested a continuance to next month. We announced that at the beginning of our meeting. Sorry if you didn't hear it.
Good evening. My name is Marcus Puddock. I'm a civil engineer and land surveyor at Godfrey Hoffman Hodge at 26 Broadway, North Haven. I'm here representing Cubtech, which is a manufacturer of medical equipment here in town. They actually own a parcel across the street from the parcel we are speaking of today. They have their existing headquarters and manufacturing facility there, and they are seeking to expand their business in town. They will be maintaining their existing building and moving a few of their employees in that building, 12 to be specific, to this new building, and adding an additional 9 employees at this new facility for a total of 21 employees at this facility. This is as I said, it's a 3-story, 30,000 square foot advanced manufacturing facility. It'll also house their online support system and training system. They ship these units all over the world, and then online, because of technology, they can train folks from this facility on how to use those units once they're installed wherever they are in the world. So let me start with Research Drive. This parcel had an existing manufacturing facility on it, and some years ago that facility burned down and was totally razed. So this is a site that has had a manufacturing facility on it previously, and we are seeking to reestablish a manufacturing use on this site. It's a 3-story building. It has parking in the front and to the side. It has two loading docks off of the end. We complied with all of the zoning in going through some of the comments that the commission provided. We believe this proposal conforms with all of the requirements within the district and zoning requirements. This is an extension of an existing facility essentially across the street, and therefore is harmonious with the surrounding buildings and the surrounding development. This is in a manufacturing zone. All of the, well, most of the units there are either commercial or manufacturing. In getting to this stage, we did have to go to ZBA twice. Once in the beginning to ask for a waiver of doing a development within or adjacent to a tidal wetland. There is a tidal wetland along the rear portion of the parcel that we are not disturbing in any way, but we are constructing adjacent to it. Our stormwater goes into some above-ground tidal basin or basins, and when they fill up, they then spill over into the tidal wetland. This entire area, all of the units all around here are all within the 100-year flood zone. So the engineering of all of our stormwater management is up to the 10-year, and we've worked with Engineer Casey in setting all of this up. Obviously, the whole place floods up to like 6 feet. Yes, yes. So we are not. I didn't check it for the 1.3. John actually, because we submitted this prior to that becoming law, and so he said that he was fine with us using the one in his comments. We certainly can review that and see if we can meet the 1.3. I believe we probably would. This building will be designed for the flood, the 100-year flood to pass through it according to all floods, requirements by FEMA. Just all of the buildings in this neighborhood are designed that way because they're all at about elevation 6 and the flood is at elevation 12. Are you raising the elevation of this building above 6? The finished floor is not. The first floor will be at, the first floor is at 8, I believe. Yes. But it will be designed to code for a flood prevention and durability, if you will. Just like their other facility is, and some of the other facilities in this area are, but it is not raised above the flood zone, no. Where was I? Well, I guess that's. Walkability between this building and their headquarters building? I'm sorry? If they're directly across the street from each other? Yes, yes. There's a sidewalk along both sides of this street. Actually, there's a sidewalk on our side, and their facility is essentially here where this legend is. Their other facility, it's almost directly across the street, diagonally. Parking question that's come up. Yep. Could you essentially command some of the parking from their headquarters side? I'm not sure. Way of solving your parking needs on this new site. So we have 25 spaces and only 21 employees. So we feel we can cover our own parking for this, and because 12 of the employees from the existing facility are coming to this one, we will be freeing up spaces at their headquarters as well. So we believe overall we will have enough parking for. You have a conference room for 100 people.
Yes, and that would be on a very rare occasion, and those would be for conferences where they would bus folks from local hotels.
Okay.
For like Salesforce from all over the world that would then come. So they wouldn't be driving there anyway. I'd be happy to answer any questions. I'm not sure what else you would like to know, if there's any specifics about the site or the engineering or
This,
the
I guess,
business
is
itself.
engineering. My question is, we're sitting, this is in a flood zone that
Yes, it
floods
is.
regularly, and within the next 20 years, we're talking about 20 inches of a rise in water, well, yeah, thank you. Sea level is what I'm looking for, which means that you're going to be dealing with this daily. Have you engineered this into the building? Sounds like you've thought about it a little bit.
Yes, it will be engineered into the building, that the 100-year
So
flood.
you have breakaway walls or breakaway
Yes,
panels? and
all of the
those
things
kinds
that
of
are
things.
required will be engineered into the building.
I'm happy to hear
such
this.
as- Yes.
Because
it's required, otherwise I couldn't get insurance.
Stratford's in a problem in that all of our manufacturing land is essentially
In a
in a flood zone.
Yes.
So if we're going to continue to have manufacturing where it is now, we've got to come up with some way of you not coming back 5 years from now saying, my building floods every day, what are you going to do about it? You know,
Yes.
because there's a lot you can't do about it.
Yep.
I know that just up 500 yards from here is Bruce Brook, that we're spending millions of dollars on trying to remediate that. So that will have an impact on the water that courses through your area. I don't know if it'll be good or bad, but it will have an impact on that
Yes,
water.
they built their existing building, I think it was 2018, 2019, not that long ago, and it also had all of the required floodproofing and whatnot. In order to get insurance of any kind, they had to do that, and they have limited things on the first floor, if you will. So there's shipping and receiving, and there's a little bit of other stuff, but a lot of the manufacturing and
I
whatnot
noticed.
happens on the higher floors that are above the flood.
Can you explain something to me? Because I haven't seen this image. There's a two-story, is that a pop-out, or is that is that just a glass wall, or is that actually a cutout?
There is a cutout for the loading in the back corner.
Yeah.
In this front corner, which is the front corner you're seeing there, that's just glass. It's not cut out. It's all.
And that's facing the road?
That's facing the road and away from Lordship Boulevard.
Okay.
So Lordship Boulevard
So
is
there is a
down
full
here.
3 floors.
There are full 3 floors.
It's just that one has a 2-story glass wall. Okay.
It has a slightly larger glass, yeah. The first floor is fairly tall for the cranes and whatnot for loading.
From what I can
purposes and
see,
whatnot.
ARB liked what you've done here. I think they had a couple comments about hiding stuff on the roof.
Yeah, and we did, obviously, we went to ARB, and we're willing to comply with most of the comments they made. They asked us to consider revising the transformer and dumpster, and we've looked, and there isn't, this site is very, very tight. There isn't anywhere else to put it, but we've tried to plant around it with attractive plants, and we agreed to, put a good, solid privacy screen.
You're a tech company. Use some bold graphics on it.
They'll do something. They want this place to look nice as well. So those will be covered. We don't believe you'll be able to see the mechanicals on the top of the roof. And so with the slight eave that we have, we believe those things will be hidden to comply with their first comment. I had a list here. We already talked about the trash. They want to leave the main entrance the way it is, the way it appears here on this this plan. They had been asked whether they could enhance it a little bit more, just to pump it up, and the owner would would rather not, and for a specific reason. They want this building to look nice, but not nicer than their existing building, because that's their headquarters. And so this is a secondary building. They want it to appear to be a secondary building.
But you're only looking at two 20-foot or 40-foot tractor trailer, right? You have a two-bay pull-in?
It's only one. That's
Oh,
for the
it's a
larger
one-bay
tractor trailers.
pull-in?
The other is not sunken. It's just a drive-up door.
I was looking at
And
the-
they believe, I'm told, I'm not there day to day, so I don't know for sure, but I'm told they have very limited large tractor trailers that arrive there. It's not a common occurrence. Most of their stuff goes out on smaller vehicles.
Their tractor trailer, though, in the plot that I looked at, is actually going out into the public street, or at least into the right-of-way, when it pulls into the loading dock. Are you aware of that?
Their existing facility,
No, this, in terms of the plans, if you look, they're, well, it's not, I guess it's the turning, when it's pulled all the way back into the bay, if you look, it's going all the way up and almost to the edge of the right-of-way.
there is enough distance here where it does not overhang a right.
It doesn't go into the sidewalk
it
area that's
doesn't
in the right-of-way?
overhang
Okay,
no.
I'll take your,
So we have just enough room. That's why there's this cutout to push the trucks far enough
Okay.
back so that it wouldn't overhang the street. It's obviously such a tight site that it's difficult to get a big truck in there, and they don't anticipate that they will have a lot of them, and so this was the best configuration I could come up with to alleviate.
I'm gonna ask you a harder
your
question
concerns? Okay.
now, if I could.
Sure.
The setback area is 15 feet, Jay, or 10?
10.
I'm not sure, is it 10, is that what it says?
The 10-foot landscape, and then then the front building setback is 20.
So you're actually, I guess what I'm saying is you're taking up 5 feet of that for parking? If you
Of the
do
tractor trailer, yes.
No, for your, in your regular employee parking lot. If you look at that, you're giving us a setback, but then you're taking back part of the setback to use as parking.
Well, the landscape setback, we fully comply with the landscape setback, which is the 10.
Right,
And then the front building setback line
that's 15,
is,
correct?
is the, I think it's 20 overall.
Okay.
And yes, some of our parking is within that.
So
the
that's,
drive
let me
the
stop
drive
here and
aisle.
ask Jay, if their parking is going into the setback area, is that a problem?
No, the parking complies, other than the variance for the total number of spaces for the site, the parking and the landscaping requirements as part of that parking lot all comply with the zoning regulations.
Good, I can live with that. That's my,
We
that
did
was
the
my
best we
question.
could.
I'm now gonna turn it over to our committee members. Len? Deborah? I think you can go. No, wait, we'll discuss this afterwards.
Yeah, you have to see if anybody in the public wants to speak.
Excuse me? Oh, I'm sorry.
Yes, we'll let
Yeah,
we'll let
well,
anyone who might want
okay.
to speak, go ahead.
All right, now, thank you very much, though, I appreciate it. And I'll just make a comment, it's a great-looking building.
We appreciate that.
I know your chairman is a real go-getter, and it shows in this, what he's doing here. Is there anybody here who would like to speak in favor of this proposal? I'll ask it a second time. Is there anybody who would like to speak in favor of this? Hearing none, is there anybody who would like to speak against, in opposition to this? One more time. Is there anybody who would like to speak in opposition? Jay, do we have that drawing? I think that's such a good model for ARB. That would be so good for.
Move that we close the public portion.
Second.
All in favor?
Aye.
Okay, we're now going to go on to our
I'll withdraw my motion. Close the public portion.
All those in favor? Aye. 5-0.
Open the administrative session.
Will someone make me a motion to open the administrative?
I just did.
Second that, I'll second that. All in favor? Aye. 5-0. Okay. So, 225 Lordship Boulevard is our administrative items, but, Jay, all we said was, do we need to vote on the, policy? Do we need to vote?
So before I answer, I think we've got two of your commissioners over here who have some comments.
It's postponed till next, no?
So all you did during the public hearing portion was close the application. And so now, there's no more public comment, and you can decide whether you want more time to think about it and leave it on the table and defer to next month and bring it up next month. Or you can choose to vote on to either approve or deny it. Attorney Sullivan, you feel the same way?
I was just following the administrative items, and I didn't see it here, so I was,
It should be the first item on the agenda.
got it.
What are we? No. So we are now working off the work agenda. It's the second page. And the first item is to vote on our public hearing items or defer them to next month. So the first item on the administrative agenda is the modification of Bluebird Prestige versus the Town of Stratford Zoning Commission.
All right, I have.
No, I got it.
I want to make a motion.
Good.
Do we want to discuss it, or do you want to just make it vote?
We have to make a motion so we can discuss it.
Motion to deny without prejudice.
I thought we couldn't make a motion to deny. We had to make a motion to approve and then vote on it.
You can make a motion to deny. You need a, you need a second.
Linda, use your microphone.
Second.
Discussion?
Discussion, yes.
I'm going to ask our lawyer a question. Patricia, is it, if we do this, does it forestall, does it shortchange discussions amongst the parties?
No.
So they can still go and have a discussion, meet back with us next month and say, this is our position on what we've come up with, correct?
I think it allows them to have that discussion without any statutory time limits that a typical application is up against, so that the mediation or the agreement can happen to all the involved parties.
But is a month enough time?
But you're not deferring, the motion is to deny it without prejudice,
Okay,
so that the applicant can talk to the involved parties without a time limit, and then come back when that agreement is reached, if it is.
okay. Any other discussion? Ewald?
Confused on two arguments. The town lawyer argument and
Do me a favor, pull your mic down.
Oh.
Pull it right up to you. You can.
Okay. I heard the reference made here between 170 and I'm confused on those 600 referred by the applicant. I probably need some clarification on that.
Right, so when the global settlement agreement was reached, so it was amongst the Curcio parties, the town of Stratford, that was the global agreement. And that's how the 15 acres came to Roosevelt Forest, and the affordable housing project on James Farms Road was taken away. That litigation was settled. The Peters Lane litigation was settled. Orinoak Lane, and then Silver Lane came in a little bit later. And one of the reasons it came in was because they wanted about twice the number of units. I think it was 21 units on Orinoak Lane, and they didn't get that. So they were looking to make up those units. And so those units came at Silver Lane. So that's the amendment to the regulation.
No.
That's the amendment to the initial settlement agreement that allowed those units on Silver Lane. So the First Amendment had to do with the Silver Lane property. Now, it has a whereas clause in it that says, we're recognizing that this happened over on Orinoak. And here's how we're resolving it amongst ourselves, amongst the parties. And the parties to that agreement are the town and the Curcio parties. The settlement agreements, you know, we went through each one of these pieces of litigation and said, you know, there is no horse trading in zoning. In zoning, you make a zoning decision. Is it, you know, how's the access? Where are the units? Does it comply with zoning? So the decisions were made here. Some of those decisions were appealed. So each one of those cases was pending in court. So what we did was settle each piece of litigation. I came back to this board and any other board that had decision. Some of those cases were in the trial court. Some of them were already in the appellate court. So each one of those pieces came together to make the whole puzzle, which was that, you know, agreement. So what they're asking for now is to change the number of bedrooms that were approved by this commission, which sort of like pulls that piece of the puzzle out, changes the piece, and when you try to put it back in, it just doesn't fit. So the question is, in order to change the whole agreement, you'd have to change the agreement. So you need to have the cooperation of the town, the agreement of the town, the agreement of the Curcio parties, and the agreement of the commission that from a zoning perspective, those changes were appropriate. And as Attorney Kubik also said, there was a lot of public input on this. So that was another consideration when that agreement was reached, and also when the commission made their decisions about these pieces. So I hope that answers your question, but
Yeah.
I know it's complicated.
I got it, but my second question is, what would bring us to authorize this modification? Yeah, sure, it looks like it would base on the court ruling to, for 2 bedrooms, but are we authorized to vote on the 3 bedrooms without the court ruling? Because of the town attorney said the ruling was made on 2 bedrooms, not 3 bedrooms. Where do you get that?
So I think what he was saying is that there was an original approval, and that approval had some 2-bedroom units and some 3-bedroom units. Now, the applicant's attorney came in and said, oh, that was just a mistake. We should have asked for all 3 bedrooms, but they didn't ask for all 3 bedrooms. And what this commission approved was not all 3 bedrooms, and if it had been all 3 bedrooms, they wouldn't need to be back here. So basically, the initial approval included 2 and 3-bedroom units. Now they want them all to be 3. So that's where the requirement comes in. And so normally when you settle a case or when you modify a judgment, all the parties go in together. So all the parties to the litigation and all the parties to the settlement agreement first come to an agreement. Okay, let's try this, let's try that. And then each one of those pieces, so we would have to come back to the commission and say, here's what we're thinking, is that okay with you? And does that comport with zoning? And then you would make a decision, and then we would take that decision, and we would go back to the court and say, all the parties have agreed, and the commission agrees, and would you mind if we modify this agreement and everybody is consenting to it? When we went into court with this, as was said earlier, Justice Everly, who is a retired member of the Supreme Court of the State of Connecticut, agreed to take all of these pieces so that we could resolve them all together. But he said, in order to do that, I need you to go to every one of the judges that's handling one of those cases right now and get their permission for me to speak to all of it. So it was very complex, and if the commission is interested in doing this, that's fine, but we need to go back to the court and we need to go back to the other parties and make sure that all these pieces are together. And I guess one of the ways I would look at it is, you know, this is a request for a modification, but what if the modification, the principle of it is, what if the modification were much greater? What if they came back and said on that James Farms Road property, where we went from more than 100 units to 3 subdivision lots, what if they came back and said, well, now we're thinking 50? You know, so it's really the principle of deciding how you move, how the process moves forward.
How do we avoid that?
I think you ask the parties to all
How
come
do we avoid them from coming back and say, okay, now we want 150?
Well, so ultimately, it would be your decision as to whether that was appropriate or not. But right now, in this particular situation, I think what you need to say is, are all the parties to that agreement in agreement that it should be modified?
Okay.
That, to me, would be the first step.
And you have to,
Can I comment? Or do you want to comment?
respond to him for 1 second, then you can. I think you made the point that we have to be careful of protecting our body of zoning.
Yeah.
Because, you know, that we've already ruled out certain things we can't come back and say. You know, once you've said yes to a project, it is the project. It makes it harder. And I think that what Patricia was saying is really important. That becomes a precedent for us in the future, that we need to protect our ability to be the final word in that sense, in terms of that's local zoning regulation. That I think we do owe it to the town to make sure that we don't weaken that in any way.
I understand.
Otherwise, you're going to have every project coming in after the fact saying, oh, suddenly we're going to change it, which we have another project right here that's coming back saying we're going to change it. So we have to, it's more complicated because there's a lot of approvals that took place and it was multi-projects. And any of the old members like Lenny and I, we're sick of these projects.
Don't want to be part of it.
Get them out of here. But we still have to do our due diligence.
Okay. No, done.
Yes, Lenny?
Yeah, I can't make a motion because there's a motion on the table. But to begin with, this is different for us because it was a negotiated agreement between the town and the petitioner. My opinion, the best way to get rid of it would have been to grant the petition with the stipulation that they go back to court and get it approved by the court, that this agreement's not being violated. And then we'd be done with it. But to deny it without prejudice, they'll be coming back. They'll be back here again.
No.
Commissioner Petroselli, while I agree that sounds like the most expeditious way to handle it. I mean, there's plenty of case law that says the zoning commission cannot condition an approval upon another
That's
agency.
many pending.
And so I think that's what it would be doing. And, you know, the town attorney is welcome to comment on that. But my job is to help make sure that you all are making the best decisions possible and not endangering or making the, we're insulating you all from appeals. And so that's all I'm trying to do, and I think that, I'm not sure you can condition an approval with another agency saying yes as well.
We don't allow alternates to speak, Your Honor. If you can't vote, you can't speak. Only in the administrative section.
My apologies. I think Jay is right. You cannot condition an approval on something that you have no control over.
Is it an effective strategy to simply say, if the judge approves it, that will reflect on everybody else in agreement? Or having tried to be in agreement?
I think you need, first of all, to get the parties to the agreement to agree that they want to, what it amounts to is amending the settlement agreement. Because originally, the settlement agreement included plans that show 2- and 3-bedroom units and not all 3-bedroom units. So if that settlement agreement is not, if everybody doesn't agree to change that, then it doesn't move, then regardless of what this commission did, it wouldn't, the town would still be in a position to say, you can't do that because you agreed to these specifics.
The current approved zoning map says this is what we've approved.
Exactly.
Yes, Lenny?
So what kind of negotiations can take place if we deny it? So what would the, why would you want to negotiate if you were the town? Put myself in the town's position. You got denied. What am I negotiating for?
Well, I think the question is, you have an agreement, you've agreed to it. If the terms of it are going to be changed, then the parties to that agreement have to agree to change the terms. And the parties to the agreement haven't agreed to change the terms yet.
That's my point. That's why they came here. So now that we denied it, there's really no purpose for the petitioner to try and negotiate.
Well, if they ask the town and the town agrees that the settlement agreement can be modified, then they can come back and ask zoning for its
And
opinion.
that goes to Deborah, dismissal with,
Without prejudice.
without,
Yeah, with the
It allows the
prejudice, yeah.
applicant to come right back.
No, without prejudice,
Without
means that they can come back without,
so if they come back and they haven't moved anybody in any situation, the lawyers are gonna say, we never settled anything.
That's, I believe that's why we are without prejudice. I mean, that means that person can come back. Well, if they fix it, if they fix the problem, if they get together, they lines together, they
I'm
can
not
come
going to
back.
argue the point.
All right, anybody else? We have a motion from Deborah that says deny with prejudice. Without, I'm sorry. Without prejudice. Are we ready to vote? Do we need to do a roll? Doesn't matter, right?
Request roll call.
Ewald,
Deny without prejudice, yes.
Linda,
No.
Deborah,
Yes.
Lenny,
No.
Harold, yes. So that gives us 3-2. Is that a valid vote? Okay. Thank you, guys. Thank you. Go off and get some work done. All right, we have text amendment.
The text amendment and 225 Lordship Boulevard special case have been continued to the February meeting.
Okay. 10 Research Drive, that's the beautiful building in the swamp. Discussion, open Someone give me a motion to take it off the table?
Motion, take it off the table.
Second?
Second.
All in favor?
Aye.
Okay. Discussion. Did I hear motion? Oh, I thought we just did. A motion to discuss?
You need a motion and then a second.
And then
Once you have those,
And then discuss.
then you can discuss.
I thought we did.
We did a motion.
We did a motion,
And we had a second?
and we had a second, and we voted, I thought.
No, now we discuss.
Yeah, now, that's what I was saying, discussion.
Motion to discuss.
Was I right? Okay,
Yeah.
good. We get tired at this time. It's really, we try not to bite. All right, anybody, comments?
I like it.
Yeah.
Look, there are things, my attitude towards it, there are things you can pick apart on this project, but if you look at it as a whole project, it's a darn good project.
Yeah.
It's a pretty building in the middle of a mess, and they seem to be aware of the fact that it's a flood zone. So they are building a building that will have better chance than any other building around it in the next flood.
Jay wants,
Yes, Jay?
And I'll just go over my recommended conditions of approval if the commissions decide that they want to do that, want to approve it. The first suggested condition is that the applicant shall obtain a letter, this is our standard condition, a letter from a licensed engineer ensuring the project's compliance with the town of Stratford's MS4 stormwater permit. This letter shall be delivered or emailed to the Office of Planning and Zoning and kept in the applicant's file. Number two, all recommendations made by the Architectural Review Board in their memo December 15th, 2023 shall be strictly followed. Prior to applying for a building permit, the applicant shall receive written confirmation that from the Architectural Review Board Chairman, ensuring that the applicant's final plans satisfy the intent of the Architectural Review Board's recommendations.
I have a question on that. Why do they have to do that?
Why does-
Well, we do the stipulations, it's part of what we approve. Why do they have to write to the Architectural Review Board Chairman should we do that with every commission? To me, it's just like
Yeah, we do, because that makes it official
makes it official what?
from the developer that they're agreeing.
It's official when he gets approval from us with the stipulations.
The problem is ARB is not statutorial.
Which brings up my other comment, can
I
they
can
do that?
explain, I can answer that.
Okay, go ahead.
So, our staff are not architects, so it may be the last time that you see this application, but we will see this application probably several times over the next few years, probably in multiple phases of building permits. So our staff are not trained architects, and the intent is to have to make sure that the architectural elements as approved by a board of architects are saying that's correct. You have satisfied the intent so that myself and my staff who do not have architectural degrees are not saying that, I assume that you read the conditions, the recommendations, they're talking about things that are very intricate design standards that are difficult for a layperson to interpret. And so we asked them, they had many complaints that staff was approving projects, and that's not what we said. What we said was we want to center the pilasters underneath the center of the windows, and certain mullions need to be used, and us as staff only have a certain capacity. So that allows us to ensure that, if you want their conditions in the project, this is what we felt was the best way to do it.
Shouldn't it be, though, before a CO is issued, not before a building permit is issued?
But wouldn't you want it built in the beginning?
Okay, so they say, yeah, we're going to do it. Now, who follows up to make sure that's being done during the project?
So that's the final inspection. We require the plans up front to have the recommendations that you all give, as well as the Architectural Review Board. Once they're designed in, now we know that the plans that we are holding that were approved are the ones that we're checking to make sure it has actually been built.
it's crazy.
I don't expect you because you're not
Well, I
staff
just
to my
don't-
department, I don't expect you to understand why that process works, but we felt that it was really honoring the recommendations that you all are attaching.
I don't have a problem with honoring recommendations, it's with contacting the chairman of the Architecture Review Board.
You know,
I mean, he's
I
not
don't
even a
vote on
paid-
this commission,
he's
so
he's
you
not
all
even
may
a
feel
paid
that that's
employee.
inappropriate. You may all feel that that's an overreach, and if you do, then it makes it easy for us, because it's less work for, this is more work for us.
Can I interject, though, the long term? What we trying, in my time here, there was no ARB when I first started coming to these meetings. We are trying very much to increase the professionalism of a designed city.
You're missing my point. I am not saying about the Architecture Review Board. It's that particular item that the chairman has asked for, not the Architecture Review
Okay.
Board.
What is the particular item?
That they have to check back in. And again, I completely understand what you're saying, because it's more work for myself and staff to do, to coordinate this, which we help to do. So we will take your direction on that going forward.
Okay.
So that was item number 2. And I just wanted to add that there's enough flexibility in the Architectural Review Board comments that they are to consider these changes. And so the item like a relocation of the dumpster, spatially, that's not possible. And so they, as long as we can determine that they have explored that, genuinely, well then, if you can't do it spatially, there's no way to do it. And we believe they have fulfilled the intent of the approval. So I just wanted to clarify that. Item number 3, the applicant shall receive a letter from the conservation superintendent that they are satisfied with the proposed planting selection. And last, all necessary siltation and erosion control shall be in place and the zoning enforcement officer notified for an inspection prior to any site construction work being performed. That's all I have.
I have to say that the landscape designer that they hired for this project, though, did a really good job in terms of doing native plants and all of that. So I can't imagine conservation is going to have terrible things to say about that if they ever do comment on it. Any other comments? Are we ready to vote?
Don't we have a motion to approve? Do we have it?
Yeah, well, gotta make one.
Oh, we need a motion, I'm sorry, we need a motion to include Jay's
Motion to approve with Jay's staff comments.
staff comments. Does that include ARB?
Yes,
And ARB as conditions?
yes.
Second.
Second? Linda?
Yes.
All right, all in favor?
Aye.
Aye.
5-0. Okay, let's go to the next one. These two are not, we're not doing anything on these next two. That's for next time. Approval of the minutes. No, no.
No, I am the minutes police. I do have one itty-bitty typo. Kind of in the middle, it says, Mr. Watson elected as chairman of the zoning commission for the year 2023. It should be 2024.
That's right. Otherwise, I can take a vacation right now.
That's the only thing. Usually, I do tell her, like, ahead of time, oh, just fix that. I don't like have to bring it out in public.
Please keep her in your good wishes,
Yeah,
because I'm sure she's having a tough time.
yeah, I know. Anyway, that's my only, so, motion to approve with that change.
Second?
Second.
All in favor? Aye, 5-0. Okay, nothing for administrative site plan review, campsites. We're not doing lordship.
No.
Do we need to do anything for research?
Yes, we do.
Okay,
I will give you the overview of, just let me pull my file out here to Research Drive. So we received staff comments for our coastal site plan review referral. and we received those yesterday afternoon, so they did not make your packets. However, they were left in front of you when you got here today, and I recommend you can turn to page 3, where Deep staff had provided us with 3 comments and 2 conditions. One of them,
Tech Drive?
this is for
Research
10
Drive?
Research Drive.
Okay.
So 3 comments and 2 recommendations. And they recommend that if the commission approves, that they approve it with these conditions: compliance with all FEMA requirements, which they have to do anyway, and installation, inspection, and maintenance of adequate sedimentation and erosion controls, which our staff will do with the condition that you gave on the special case. So,
On the special case.
for 10 Research Drive.
And he actually said that they would look into the 1.3.
And so that will be negotiated between the town engineer and the applicant when they apply for a building permit. If something has changed or a code has updated, that's where our checks and balances come through with the workflow for a building permit. So my recommendation is that just those 2 conditions and the deep comments dated review complete dated January 18th, 2024. That's all I have.
And then we need to make a comment also that this definitely supports the POCD. Any other comments, anybody? Does someone want to make a motion before you all start packing up? No, sorry, we have a lot more to do. Someone want to make a motion for this?
Motion to approve the site plan review?
With Jay's comments? Did you get enough of that? Okay.
With Jay's comments attached, sorry.
Okay, so we're going on to the next one. I keep losing my pages.
Okay, thank you. And the next,
We need a second.
oh, I'm sorry. Jumped in
Linda.
here.
Linda. All in favor?
Aye.
5-0. Thank you. All right, let's go to the next one.
Thank you. We have an item for 556 Bridgeview Place. This is for the construction of an 88-foot long by 4-foot wide fixed timber pier and a 35-foot long by 3.5-foot wide gangway to lead down to the pier, which will, I'm sorry, not lead down to the pier. It'll lead down to an 8-foot by 12.5-foot floating dock. And the conditions that were provided, I'm sorry, let's pull out these conditions. The conditions we received from Deep today, so those were also left in front of you because we just received them today. Their one recommendation is that the maintenance of adequate sedimentation and erosion controls during construction, and we recommend that you attach that as a condition of approval.
And Jay, is there anything we would ever do for when there's high tides in the Housatonic? Is there any precautions they have to take that should be included?
So I have to be honest that I am not a boat person, and I'm not 100% sure what the procedures are in the event of a coastal storm event. I know, I can just tell you from experience, my wife's family has something quite similar to this, and during large coastal storms, they will detach them and then barge them off to a safer area.
Yeah.
And so I think that if the applicant is that's something they don't want to rebuild their deck or floating dock, that's what they'll need to do. It's a relatively smaller structure. It's 12 by 8.
But that's not something that DEP is gonna, or coastal resource, or
No.
any of those people are gonna say,
As does not appear to be a requirement from
Okay.
DEEP, nor is it a requirement for the town of Stratford.
I'm the engineer of record, if I can speak and.
Nope, cannot speak, I'm sorry.
Oh, which I would know that.
Well, unless the zoning commission decides they want to waive the rules, but then we have to open it up to the general public in favor or in opposition. We didn't advertise for it. So
yeah, I'm gonna make,
my recommendation is that we do not do that.
I will
Leave it up to you.
concur.
Sorry.
And if you looked at the drawings, they're well done drawings. It looks like it's well engineered. Do we want to vote?
Yes, sure, why not? Motion to approve.
With Jay's recommendations from the DEP?
Correct.
With the DEP recommendations?
Yes, whatever you said.
Second,
And a promise that we can come and sit on the dock one day, but. Happy hour, a little happy hour for zoning.
And this is to protect your applicant. We would love to hear what they say, but.
Is this in lieu of a hearing, or does this still go to a hearing?
No, this is, they can choose, the commission can always choose to send this for a public hearing, but they are choosing, it sounds like.
Motion to approve.
Yeah, we're gonna approve it.
Administratively now, so.
Your drawings look great. Yes, are we ready to vote? Discussion? Did someone second it? Deborah seconded. Discussion?
Go ahead, all those in favor say aye.
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 Ewald?
Enjoy your dock.
Did he say? Ewald? Did you say aye? Okay, 5-0. All right, let's go to the next one. Sediment and erosion control applications. We're not doing lordship, we're not doing research, we're not doing sniffins. So that's it. Oh, I'm sorry. Oh, my apologies. We're doing 10 research.
Thank you, Mr. Chairman. As part of my staff comments for all the applications submitted by the applicant, I recommend the 4 standard conditions of approval for an erosion and sediment control, that the proposed soil and erosion and sediment control design and implementation shall comply with the 2002 Connecticut Guidelines for Soil Erosion and Sediment Control. Number 2, all necessary siltation and erosion control shall be in place and the zoning enforcement officer notified for an inspection prior to any site construction work being performed. Number 3, immediate on-site modification shall be employed when an erosion problem develops. And number 4, in evaluating this application, the Commission has relied on information provided by the applicant, and if such information subsequently proves to be inaccurate or incomplete, this approval may be modified, suspended, or rescinded. Those are my 4 recommended standard conditions.
Also, planning voted on this, so I'd like to include planning's letter with the exception of number 2, because I think that's already been determined that it's not possible. But it looks like planning's letter,
I don't think, no, this didn't come before the Planning Commission. What do you have here? That's for 10 Research Drive, sorry.
where am I?
Look, we're on 556, oh.
No, that's what
wait,
we are
I'm
on.
sorry. The Planning Commission, that is the Architectural Review Board, Mr. Chairman.
Oh, it is?
It's not the Planning Commission, I'm sorry. It got me confused for a second there.
Oh, you know why? Okay, it's because
And
it's,
research.
it's because this is Smith's name.
Yep.
So what I'm saying is, do not include number 2 because it seems like that's not possible anyhow. Does that make sense, everybody? So what else do we need to do for
I think we just need a motion to approve with the
sediment?
conditions for that application. with the state
Ewald,
conditions.
let's do it. You want to do it? A motion to approve with conditions as cited by Jay.
Yes. Motion to approve, yes. With condition. Motion to approve
You have to say the whole thing out,
with condition.
with conditions as outlined by Jay.
What?
Conditions as outlined by Jay.
Oh, okay, my dear.
Sorry.
Okay.
Second? All in favor?
Aye.
Aye, 5-0. Anything else, Jay?
No other sediment erosion controls for this month. We can just move to item number 7. If anyone has any enforcement, any issues with enforcement or complaints, I always recommend you can always email me directly, and I'm happy to pass along to staff.
A paper shredder, how about that? Our next meeting is February 28th. Why do I have February 14th?
I'm thinking of a public hearing.
Is the 14th the meeting with the rewrite committee?
So currently, we don't have a meeting scheduled with the consultants for the zoning regulations update. We're still putting together some edits for you all to look at. So as of right now, we do not have a dedicated meeting with the consultants for January 14th, which is on Valentine's Day. So we might be able to have your Valentine's Day dinners. But the next public hearing is on February 28th.
Okay.
I just want to remind everyone, we had a lot of continued items tonight. Please hold on to those documents for next month. You're going to need them for next month.
That's 225.
Correct. That's the text amendment for Section 32, the special case for 225 Lordship Boulevard, the 7365 Main Street, and the 500 Sniffens Lane. Anything with those numbers on them, with those addresses on them, keep for next month.
And Jay, we had,
And if you lose something, and you knew you had it but you misplaced it, let me know, and I'll try to send it back out, get it back out to you.
I know John is, Casey's always busy, but if there's any way we can hold him to what we hold everybody else to.
Oh, he is certainly doing even more than what you're conditioning.
I hesitate to say that, but it's hard because we didn't get to use what he spent time pulling together. I need a motion to adjourn. Hey, you know what? Thank you, committee. I think we did a good job tonight with a lot of stuff. What, you want me to take my name out of it? All right, I will. That's a gift to Lenny. Thank you. I don't see you for